Hello and welcome to ProfDale's Property video number 45. I'm your host, Dale Whitman. In this video, we're going to provide an introduction to the law of mortgages. So what does a mortgage loan transaction look like? Well, generally, there are two parties or groups of parties. There's the lender and there's the borrower or borrowers. In a residential transaction, frequently the borrowers are a married couple. So the lender, of course, provides a loan, advances money to the borrowers. Often that's to buy a house. The borrowers, in turn, submit two documents to the lender. The first is a promissory note promising to pay back the money. The second is the mortgage, which is security for the money. The borrowers are known as the mortgagors, and the lender is known as the mortgagee. Now you'll notice that many people, when they talk about mortgages, say it backward. They say, I'm going to go to the bank and get a mortgage. No, you're not. You're going to get a loan, and you're going to give the bank the mortgage and also the promissory note. So the borrowers are the mortgagors, the lenders the mortgagee. The promissory note, as we've said, represents the borrower's obligation to repay the money. The mortgagor signs the note and delivers it to the lender. The note says things like this: I promise to pay a certain amount of money plus interest to the order of the lender. I will pay interest at a certain interest rate. I will pay interest and principal by making a monthly payment in the amount of so many dollars each month. The promissory note's a relatively simple document, usually just a couple of pages long. Now, the mortgage, on the other hand, is security for the obligation. It doesn't say the borrowers will repay the money. Instead, it's there to help the lender collect the debt by selling the real estate if necessary and using the proceeds of that sale, we call that a foreclosure sale, to pay off the debt. The mortgage follows the note. That is to say, the original holder of the mortgage, the original mortgagee, may transfer the note to somebody else. If they do, the mortgage is considered to go along with it automatically unless there's a clear contrary intent. So whoever can enforce the note can also enforce the mortgage. If the borrower defaults in making the payments on the note, the lender has a couple of choices. First, the lender could sue directly on the note, much like an ordinary contract action, and sue for the money. Alternatively, the lender can foreclose the mortgage, and that is what happens most of the time, because foreclosing the mortgage seems like the most certain and immediate way to collect the money from the borrower. The lender has a choice about which of these to do first, except in about 8 states. Those states have so-called one action or security first rules. Those two phrases mean the same thing, and in those states, the lender is obligated to foreclose the mortgage before suing on the note. The lender has no choice about it in those 8 states. How does a lender generally realize on the security? As we've said, by foreclosure of the mortgage. And when we have a foreclosure, literally, it forecloses the borrower's right to own and possess the real estate. It takes the borrower's title to the real estate away from the borrower. It also forecloses the borrower's right to redeem the real estate from the mortgage by paying off the loan. That's a valuable right that borrowers generally have. But when the foreclosure is completed, the borrower's right to pay off the loan and keep the real estate has now been cut off. There are two methods of foreclosure that are common in the United States. The first one is a judicial action. It's an equitable proceeding, and it's filed by the holder of the note and mortgage. All states have judicial foreclosure. The other method is called a non-judicial foreclosure. It generally involves giving notice to the borrowers, advertising the sale, and then conducting the sale without any court supervision. There are about 30 states that have non-judicial foreclosure procedures as well. And in the states that have non-judicial procedures, the great majority of the foreclosures in most of those states are done by a non-judicial foreclosure. Either method, either a judicial action or a non-judicial foreclosure, leads generally to a public auction sale of the property. There's an exception for 3 New England states, Connecticut, New Hampshire, and Vermont. And in those states, they don't necessarily have a public auction sale of the property. Instead, the lender, at the completion of foreclosure, simply takes title to the property and becomes the owner of it. We refer to that as strict foreclosure, but only those 3 states generally foreclose by strict foreclosure. So why is it so helpful to lenders to have secured credit in the form of a mortgage on real estate when they make a loan? If the lender didn't have any mortgage or other security, how would the lender enforce the delinquent debt? Well, the answer is the lender would bring a suit on the promissory note and get a judgment. And in virtually all states, a judgment becomes a lien on the defendant's real estate. Now you might be thinking, well, isn't that just as good as a mortgage? But as it turns out, mortgages are strongly preferable to judgment liens from the point of view of the lender, and the reason is the date of priority of the lien. In the case of a judgment lien, it only takes its priority from the date that it's filed, and that's normally right after the judgment is obtained. A mortgage, on the other hand, takes priority from the date it's recorded. So what that means is that mortgages generally have a much earlier priority date than judgment liens do, and that means in turn that they will take priority over any intervening interest in the property. Lenders generally loan on much more favorable terms if they can get security in real estate. Real estate is considered one of the most desirable forms of security that a lender can get. Now, most mortgage loans are what we call fully amortized level payment loans. Let's see what that means. First of all, because they are level payment loans, that means the borrower makes a payment every month in the same amount. The payment is more than enough to simply cover the interest that accrued on the loan during the previous month. So in other words, the payment covers the previous month's interest, but there's more in the payment than just the amount necessary to cover that interest. The extra money is applied each month to reduce the principal amount of the loan. So over time, the principal amount declines. And what that means in turn is that eventually, if the payments continue long enough, the principal will be fully paid off, or as we say, amortized. That's why it's called a fully amortized level payment loan, because over time, the payments on principal will fully pay off the loan. Here's an example. Let's suppose we borrow $100,000 at an interest rate of 6%. The loan term, let us say, is 30 years. And those numbers are quite typical of residential mortgage loans in America. Now, the monthly payment on that loan is going to be $600. How did we know that? Well, to get that figure, we need either a table of loan payments or a financial calculator like the one in the picture there. Let's assume that the loan is made on January 1 of the year 2020. At this point, we can build an amortization table. An amortization table shows each monthly payment, the amount of the payment, the amount that goes to interest, the amount that's used to reduce the principal, and the balance after the principal has been reduced. So what happens on the 1st of February in 2020? We make a payment of $600, but if you do the math, and you can almost do it in your head, 6% per year is 0.5% per month, and 0.5% of $100,000 is $500. So we owe $500 of interest on the 1st of February, and that means we've got an extra $100 to use to reduce the principal on the loan. That means that after we make the loan payment, our balance on the loan will have gone down from $100,000 to $99,900. On the 1st of March, we make another $600 payment. This time, the interest is a little lower because we're calculating the 6% interest, or 0.5% per month, on the lower balance that we got by making the previous month's payment. In this case, the balance of $99,900. So our interest is a bit lower. It's $499.50, and we have a little more left over that we can use to reduce the principal, $100.50. So we'll apply that to reduce the principal balance, and after we make the March 1 payment, the balance on the loan will be $99,799.50. On the 1st of April, we do the same thing. We pay the same amount of monthly payment, $600. The interest, however, is a little less because we're computing it on a little smaller principal balance, on the balance that was left after we made the March 1 payment. So our interest is only $498.99. That leaves us $101.01 to use to reduce the principal balance, and that means the balance is now down to $98,698.49. We simply continue this process all through the 30-year period, and when we get to the last payment at the end of the 30th year, the very last payment will have exactly enough principal reduction to completely pay off our loan, and our loan is then fully discharged. If we drew a graph to show what the balance on this loan looked like over time, we'd see that it starts out at $100,000. 30 years later, it obviously has to go to zero. But you'll notice it's a kind of a bulgy curve. The balance declines slower in the early years and faster in the later years. If our interest rate were higher, this is a 6% interest rate, but if the interest rate were higher, the curve would be bulgier. That is to say, it would decline, the balance would decline more slowly in the early years and faster in the later years. Now, what if we were able to change the interest rate? What effect would that have on the monthly payment? We've already said that on this $100,000 30-year loan, the monthly payment is $600 if our interest rate is 6%. But let's look at some alternative interest rates and see how they would affect the monthly payment. If our interest rate were 4%, the payment would be only $477 a month. At 5%, it would be $537 a month. At 6%, as we've already said, it would be $600 a month. At 7%, $665 a month. At 8%, $734 a month. At 9%, $805 per month. Now, lenders impose a maximum payment to income ratio. The exact percentage that they require depends on the lender. It's generally between 36 and 43%. And what that means is that a borrower won't qualify for a loan if the loan requires a higher payment in relation to income than that percentage. So the result of having higher interest rates is that they tend to ration borrowers out of the market. As interest rates go up, fewer and fewer people can afford to buy a house or build a house. Over time, U.S. interest rates have fluctuated widely. There was a period in the early 1980s when they reached nearly 20%. Needless to say, during that period, people found it exceedingly difficult to borrow money to buy a house. In the last 3 or 4 years, interest rates have been quite stable. In fact, since about 2012, interest rates have fluctuated between about 3% and 5% in the United States. And those interest rates are very low by historical standards, as you can see from the chart. The result is that it's been relatively easy for people to qualify for a mortgage loan to buy a house since about 2012. Now, if you wanted to borrow money to buy a house, but you were concerned about how high your monthly payment would be, what could you do to reduce the monthly payment? Well, it turns out that your options are quite limited. One obvious thing you can do is reduce the principal amount by borrowing less money. But what that may mean is buying a house that isn't as adequate for you or your family as you would like to have, or perhaps moving to a part of the country where housing prices are lower. A second option is to reduce the interest rate, and there are a few programs available, often through state housing finance agencies, that do indeed offer lower interest rates, particularly to first-time home buyers. But for most of us, the interest rate is simply a function of the market, and there's not much we can do about it. The third opportunity you have to reduce your monthly payment is to lengthen the term of the loan to maturity. But it turns out that if you lengthen the term much beyond 30 years, it just doesn't have very much effect in reducing your monthly payment. The chart on the next slide will show why this is so. In this chart, we're assuming that we have a $100,000 loan with a 9% interest rate, and we're going to vary the loan's terms. They could be as short as, looks like about 8 years at the left end of the chart here, up to about 40 years. You'll notice that the chart is very much curved and gets closer and closer to the $750 figure of interest only. Obviously, it never quite reaches $750, but we can't get below $750 no matter how far out we extend the term. And you'll notice there isn't very much difference between a 30-year and a 40-year term in terms of reducing the monthly payment. Now, not all loans are fully amortizing. For example, the loan payments might be based on a 30-year amortization schedule, but the full balance might become due after 10 years. This sort of loan is not very common with residential properties, but on commercial properties it's quite common to see this sort of arrangement. In this example, after 10 years, remember we borrowed $100,000, after 10 years we'd still have an unpaid balance of $83,686. You can see the balance doesn't decline very quickly in the first few years. We refer to that $83,686 as a balloon payment, and in this type of loan, which isn't fully amortizing, then we'd need to come up with the cash to pay that balloon payment after 10 years. Or alternatively, we might go back into the market, look for another lender to make us another loan to refinance the $83,636 balloon. Now, there are many other variations on the fully amortized level payment loan. For example, our loan might have, instead of a fixed rate, an adjustable interest rate. The rate might adjust once a year. It alternatively might not adjust at all for the first 5 years and then begin adjusting thereafter. There are many arrangements that can be made here. Generally speaking, adjustable interest rates loans carry lower initial interest rates than fixed rate loans do, so they may be attractive to some borrowers. Another possibility is a graduated payment schedule. This is a loan in which the payments increase not based on interest rate, but on a fixed schedule for the first 5 years or the first 10 years of the loan. There might be only interest and no amortization for a fixed number of years. For example, the first 5 years might be interest only. In this type of loan, the balance will simply not decline during that period of time. Indeed, there might even be a loan with negative amortization, where the monthly payments are not enough even to pay the full interest, so that every month the unpaid portion of the interest is added to the principal. Now, this type of loan is considered extremely risky from a lender's point of view because instead of going down over time, the loan will go up in balance over time, and unless the property also rises in value, the lender's security, the lender's loan-to-value ratio will get worse and worse instead of better and better. Much of the terminology that we use in modern mortgage law is a result of the historical development of the mortgage in England. So we're going to take a closer look at that development now. If we go back to the late 1500s and look at the original form of the mortgage as it developed in England, in those early days the mortgage was actually a deed, but it wasn't a deed of a fee simple absolute. Instead, it was a deed of a fee simple subject to conditions subsequent. And the condition subsequent was the mortgagor's paying off the debt or loan that was owed to the mortgagee. If the mortgagor paid the debt on the proper day, then the pledge or transfer to the mortgagee became dead. And so the original term mortgage literally was mortgage, that is, a dead pledge. It became dead by virtue of the loan being paid off. If the loan was not paid off, on the other hand, then the mortgagee was allowed to keep title to the property. Now, the loans in those days were normally due all at once, not in monthly installments, but in a single payment on a fixed date, which was known as law day. And the law courts would not recognize a payment that was even 1 day late. If the mortgagor made the payment even a day late, it would be too late to redeem the land, and title would remain permanently with the mortgagee. However, to the equity courts, this seemed to be rather extreme and harsh. And so what the equity courts began to do was to say, even if the mortgagor pays a little late, We don't mind that. We'll allow them to redeem the land, get their real estate back, not have to leave it with the mortgagee, even though they didn't pay on exactly the day they were supposed to. However, the lenders of that day found that to be objectionable because they said, well, how long do we have to wait? We need some outside date after which we can say we really do get to keep the title to the real estate. And so the equity courts developed the concept of a foreclosure date. And that was a date beyond which the mortgagor could no longer redeem the title to the property. How long would the mortgagor have? Well, from the time that the law day occurred until the foreclosure date might commonly be something like 60 days or 90 days or 120 days. So there would be an adequate time for the mortgagor to get its act together and pay off the loan. But if they couldn't do it within the time that the equity court set for foreclosure, then there would be a foreclosure, the right to redeem would be foreclosed, and title would remain in the hands of the mortgagee. Foreclosure in those days was what we today would call strict foreclosure. What that meant was the mortgagee simply kept the title to the land. Remember, the mortgagee had a deed, originally a deed of a fee simple on condition subsequent, but if payment wasn't made by the mortgagor within the time allowed by the equity court, that right to pay would be foreclosed and the mortgagee would simply keep the title to the land. Today, except in the 3 New England states that we mentioned earlier, foreclosure isn't strict. Instead, it's foreclosure by sale. That means that the land is sold and the mortgagor receives the proceeds of the sale. If we need all of that money to pay off the debt, if there's any remaining money, that goes back to the mortgagor. So today we have an auction instead of just allowing the mortgagee to keep the title to the land. One of the things that the early lenders tried to do, and mortgagees still sometimes try it today, is to put a clause in the mortgage that says the borrower, the mortgagor, waives the right to redeem the property in equity. In other words, the mortgagor would be saying, if I miss a payment, even by only a tiny amount of time, I will lose my right to redeem the property, and the lender can go ahead and keep the title in a strict foreclosure state or have an auction type sale in the rest of the states. Now that sort of clause, a clause by which the mortgagor purported to waive the right to redeem, was called a clog. And the equity courts said that a waiver of that sort, a clog on the equity of redemption, in other words, was unenforceable. And that's still true today. So a clause of that sort, even in a mortgage today, will be treated as a nullity by the equity courts. Here's a little more information about foreclosure methods that are used in the United States. We mentioned before that judicial foreclosure, foreclosure in court, is available in every state. It is an equitable proceeding. Really, it's a lawsuit. The other method is called non-judicial or power of sale foreclosure. It's available in only about 30 of the 50 states. It has to be established by statute, and some states don't have any statutes authorizing non-judicial foreclosure. The states that do have it divide into 2 categories. In about 20 of the states, including all of them in the western United States, a deed of trust is the document used. Now, the deed of trust is really just a mortgage, except that it also contains the appointment of a trustee to handle the sale. And the foreclosure sale will be handled by the trustee and is called a trustee's sale. The other 10 states that have non-judicial foreclosure are mostly in the upper Midwest, and they use what's called a mortgage with power of sale. The foreclosure sale is actually held by the mortgagee. Whether it's a trustee's sale or a sale by the mortgagee, a non-judicial foreclosure usually involves sending notice by mail to the parties, the junior interest holders, putting notice in the newspaper, posting notice on the property, sometimes posting notice on the courthouse door, and then the trustee or the mortgagee can conduct the sale without any judicial supervision. Non-judicial foreclosure has certain advantages to lenders. First of all, it's generally quicker and cheaper than judicial foreclosure. Obviously, you don't have to spend the money on attorney's fees to take the foreclosure suit to court if you can use the non-judicial foreclosure. In addition, statutory redemption may be disallowed in a non-judicial foreclosure. Now, we haven't talked about statutory redemption yet, but we will in a few minutes, and states that have statutory redemption, quite a few of them say it applies only to a judicial and not to a non-judicial foreclosure. So that's beneficial to lenders. There are some disadvantages to lenders as well of non-judicial foreclosures, but they depend on the statute. It may not be available for some types of property. For example, in several states, you can't do a non-judicial foreclosure on agricultural land. You might not be able to do it on a single-family residence either. Now, I mentioned a moment ago statutory redemption. There are really two kinds of redemption. The first kind is the kind we talked about in our historical overview, namely equitable redemption. That's available in all states. It's a common law proceeding, and it's applicable only before foreclosure. In other words, the whole point of foreclosure is to put an end to the borrower's right of equitable redemption. To redeem, you have to pay the debt, and you have to pay it to the lender to whom the money is owed. Now, statutory redemption is quite different. It's available in only about 20 states, and it's only applicable after the foreclosure has occurred. It's obviously statutory. It didn't apply at common law at all. To redeem statutorily, you have to pay the amount that was bid at the foreclosure sale. You pay the person who bought at the foreclosure sale. So essentially, in a statutory redemption, you're buying the property back from the successful bidder at the foreclosure sale. Now, lenders obviously don't like statutory redemption, and they strongly prefer not to have it available in the states in which they're foreclosing, because if there's statutory redemption, you don't know until the end of the statutory period whether there's going to be a redemption or not. That period is commonly in the range of 2 or 3 months to as long as 1 year. So the property is in effect tied up for that period of time until we know whether there's going to be a statutory redemption or not. We can think of there being 3 stages in the life of a mortgage. First, there's the pre-default stage in which the borrower is making regular payments on time. Now suppose the borrower defaults, fails to make a payment. The mortgagee can declare a default and can accelerate the loan. By accelerate, what we mean is the lender simply declares that now the entire loan balance is due and owing. After that, there is a period of equitable redemption. All states recognize this. The loan is defaulted and accelerated, so in general, the borrower has to pay off the full amount in order to redeem their property and keep it from being foreclosed. But if they can come up with the money, they can stop a foreclosure by making that big payment. Finally, after the mortgagee forecloses on the real estate, there will be a post-foreclosure period, and in about 20 states, that's when the period of statutory redemption begins to run. It commonly will run, as I mentioned, anywhere from a couple of months to a year, depending on the state, and during that period, the borrower and holders of junior liens can redeem statutorily by, in effect, buying the property back from whoever bought it at the foreclosure sale. Now, here are some definitions that are important in mortgage law. The first is acceleration, and as we've already said, an acceleration means that the lender declares the entire balance of the loan due and payable. It's required that we have a clause in the note or mortgage allowing the lender to accelerate, but virtually every competently drafted mortgage will have a clause like that in it, and lenders always accelerate before they foreclose, because if they didn't do that, all they could get from the foreclosure sale would be the amount of the missed payments. Well, no lender wants to bother foreclosing just for that amount. So they want to be able to collect the entire balance when they foreclose, and to do that, they have to accelerate. Surplus is the amount by which the foreclosure sale proceeds exceed the balance on the mortgage debt. In other words, we got more money out of the sale than we need to pay off the loan. A deficiency is just the opposite. It's the amount by which the foreclosure sale proceeds fall short of the balance that's owing on the mortgage debt. Let's take a look at an example of surplus and deficiency. Let's assume we have a mortgage debt of $200,000 and there's a foreclosure sale and the high bid at the sale is $150,000. What that means is that we have a deficiency of $50,000. In other words, we're short by that amount in terms of being able to fully pay off the mortgage debt. And the lender might sue the borrower for that deficiency in a personal action and try to recover it out of the borrower's other assets. Again, suppose the mortgage debt is $200,000, but this time the high bid at the sale is higher. It's $250,000. Now we have a surplus of $50,000 after we have fully paid off the mortgage debt. And so the remaining $50,000 will go to the borrower if there are no junior lien holders. Notice that when we talk about the mortgage debt, that doesn't include just the unpaid principal balance owing on the loan. It also may include accrued interest, the costs of foreclosure, attorney's fees, inspection fees, appraisal fees. Lenders are quite marvelous in thinking up additional fees that they can tack on to the amount of the mortgage debt, and they can recover all of those in the foreclosure sale. If there is a foreclosure, who gets it? Well, we pay in order. First, the amount owing to the foreclosing mortgagee, then the amounts owed to any junior or subordinate mortgages or lien holders in the descending order of their priority. Then we pay the mortgagor or borrower the amount that is left over. If there's a deficiency, is the mortgagor personally liable for it? Well, the general answer is yes. In most states, borrowers are liable for deficiencies. We can get a judgment against them by simply suing them on the note. However, there are a few states that have anti-deficiency statutes. California is perhaps the most famous of those, and in California, there cannot be any deficiency judgment after any non-judicial foreclosure, and in addition, there can't be a deficiency judgment on any purchase money mortgage, even if it's foreclosed judicially. So you can see that the vast majority of situations in which we might try to get a deficiency judgment in California, it will be barred. Even if a deficiency judgment is theoretically available, and it is in most states, the question arises whether it's worth pursuing. If the borrower has defaulted on this loan and can't make up the default before the foreclosure sale occurs, then there's a real chance the borrower just doesn't have any other assets either, and there won't be any practical way of recovering the deficiency from them by a personal suit against them. However, many lenders say that deficiency liability is a useful incentive against default, even if they wouldn't pursue it in fact. It certainly does give the borrower an incentive to try to make the payments and not to default because of that looming risk that they might be held liable for a deficiency. You might have realized that there can be more than one mortgage on the same property. In fact, you can have as many as you want to imagine, but we'll restrict ourselves to the simple case in which there are two mortgages, a mortgage to Bank 1 and another mortgage to Bank 2. Now, to analyze these cases, it is critical to know what the priority is among these mortgages. Priority is normally determined simply by the chronological order in which they were placed on the real estate, but that assumes that they're all immediately recorded in the public records. If one of the mortgage holders doesn't immediately record his or her mortgage, and if another mortgage is placed on the property later to a bona fide purchaser, then the later mortgage will actually take priority over the earlier one. So it's critical that mortgages be immediately recorded in the public records. And in fact, most mortgage lenders are very, very careful to do that. Now, what determines the order in which mortgages are foreclosed? Well, it has absolutely nothing to do with their priority. If we have a first and a second mortgage on a piece of real estate, it's entirely possible that the second will be foreclosed before the first does. Either one might foreclose first, and it depends really on which lender experiences a default and loses patience first. That could be the first mortgage, it could be the second mortgage. When a foreclosure occurs, what happens? Well, the first thing that happens is the mortgage being foreclosed is wiped off the title to the land. So what that means is the foreclosure buyer takes the title as it existed just before that mortgage was placed on the property. Not only is the mortgage being foreclosed wiped off the title of the land, but all mortgages and other interests of lower priority than that mortgage are also wiped off the title to the land, as long as the holders of those mortgages and other interests are properly served and made parties at the foreclosure proceeding. But interests of higher priority than the mortgage being foreclosed are not affected by the foreclosure, and they remain on the title to the property. In other words, we can only foreclose downward. We can only foreclose on people who have interests that are lower in priority than the mortgage that we're foreclosing. Let's take this example with two mortgages to ME1 and ME2. As we mentioned, a mortgage can only be foreclosed down against interests of lower priority. So ME1 can foreclose against ME2 and wipe out ME2's mortgage. On the other hand, ME2 can't foreclose against ME1 at all because you can't foreclose upward. You can only foreclose downward. So let's take this example in which we have two mortgages on the property to ME1 and ME2, and we also have a lease to a tenant. Now on our screen, let's stipulate that these interests are in descending order of priority. ME1 has the first mortgage, ME2 has the second mortgage, and the tenant is in third priority position because the tenant didn't sign the lease until after both mortgages were placed on the property. So if ME1 forecloses, what happens? Well, there's our foreclosure sale, and the buyer will buy the property. What about the other parties? Well, ME1's mortgage is wiped off the title to the land because it's the mortgage being foreclosed. ME2's mortgage is wiped off the title to the land because it is subordinate to ME1's. We're assuming now that ME2 is properly made a party to the foreclosure. Likewise, the tenant's interest is wiped off the title to the land, and the tenant will have to vacate and, in effect, have their lease terminated because they were subordinate to the mortgage being foreclosed. So the buyer gets the title to the real estate with all of the mortgages and the lease removed from it. Now let's take the same facts, except that ME2 forecloses first, and there's our foreclosure sale and our buyer buying the property. What about the other parties to the transaction here? Well, obviously ME2's mortgage is wiped out. Likewise, the tenant's lease is wiped out. However, ME1's mortgage is not affected in the least by this foreclosure sale, and it remains on the property. So the buyer will take title to the property, but the buyer's title will have ME1's mortgage on it. Let's put some numbers on this example and see where that leaves us. We have $30,000 owing to ME1, $15,000 owing to ME2, and we have our tenant with the lease. Let's suppose ME1 forecloses and the high bid at the sale is $50,000. There's our buyer bidding $50,000. How do we distribute the sale proceeds? Well, we distribute them in descending order of priority, starting with the mortgage that was foreclosed. So ME1 will get $30,000. That's the amount ME1 was owed. There's enough money left to pay ME2 $15,000 and fully pay off ME2 in that way. And we still have a tenant in there who says, well, I got wiped out as well. I should get some cash as a result of this sale producing a surplus. So in some states, the tenant will be able to recover the bonus value of the lease if there is any bonus value. What do we mean by the bonus value of the lease? We mean the amount by which the fair rental value exceeds the actual rent payments. We discount both those numbers to present value terms, and if the fair rental value is greater than the amount of rent being paid, the tenant had a real economic advantage in holding that lease and should be entitled to recover some of the surplus in order to compensate the tenant for the loss of that value. The mortgagor will get the balance of the proceeds. That'll be $5,000 if there's no bonus value in the lease. What if the high bid was only $40,000 instead of $50,000? Well, we do it in exactly the same way, except that there's not quite as much money to go around. So ME1 will still get $30,000. There's only $40,000 total, so there's $10,000 left to give to ME2. ME2, you remember, was owed $15,000, so ME2 has a deficiency claim for $5,000, unless you're in a state that bars deficiency judgments. The tenant will get nothing, and the mortgagor will get nothing. We didn't have enough to get around to them. Now you can see from this why junior mortgages, such as second mortgages, are considered more risky to lenders than first mortgages. If the property's value isn't enough to cover the amounts owing on both mortgages, it's the second mortgage that takes the hit. And the first mortgage may get fully paid while the second mortgage may get only partially paid or not paid at all. So second mortgages are more risky, and that's one of the reasons that they tend to carry higher interest rates than first mortgages do. Now let's go back to our example where we have two mortgages and a lease on the property. Let's put ourselves in the position of a bidder who attends a foreclosure sale and is interested in buying the property. Let's assume that we've examined the property and concluded that its fair market value is $50,000 free and clear of all liens. If we attend a foreclosure sale and start bidding, and the foreclosure sale is held by ME1, how high would we be willing to bid? Well, as we've already discussed, if ME1 forecloses, ME1's mortgage will be wiped off the title to the land, so will ME2's, and so will the tenant. So the buyer is going to take the title free and clear of both mortgages and the lease, and therefore the buyer might be willing to pay as much as the unencumbered fair market value of the property, namely $50,000. Now instead, let's suppose that ME2 is conducting a foreclosure sale. Again, we've looked at the property and concluded that its fair market value is $50,000. How high would we be willing to bid? So here's our picture. Here's the buyer buying at ME2's foreclosure sale. We know that ME2's mortgage, the one being foreclosed, will be wiped off the title to the land. We know the tenant's lease will be wiped off the title to the land, but ME1's mortgage remains on the title. That means the buyer is, as we said earlier, going to buy the property with ME1's mortgage still on it. What does that mean as a practical matter? As a practical matter, it means that the buyer is going to have to pay off the ME1 mortgage. Now, understand the buyer isn't personally liable on the ME1 debt, doesn't have any legal duty to pay it off. However, it's extremely unlikely that the mortgagor, the original borrower, is going to pay it off because now they've lost their title to the real estate, and they have almost surely lost all interest in making payments on any mortgage on that real estate. So that just leaves the buyer. If the buyer doesn't pay off the ME1 mortgage, ME1, the lender, will foreclose against the buyer and take away from the buyer the title that the buyer just purchased. Obviously, if the buyer is interested in keeping the property, they don't want that to happen. So the only way they can avoid it as a practical matter is to pay off the ME1 mortgage. So what does this mean for people who are bidding at second mortgage foreclosure sales? Well, if the property is worth $50,000, and if the buyer is going to have to pay $30,000 in order to pay off the ME1 mortgage, then the most the buyer ought to pay at this foreclosure sale is the other $20,000 that the property is worth. If the buyer pays more than $20,000 at the foreclosure sale, the buyer will end up overpaying for the property. You can state the rule in general terms. Anyone who buys at a junior mortgage foreclosure sale should discount their bid by the amount of the balance owing on any senior mortgages, senior in priority to the one who is foreclosing. If they don't, they'll end up overpaying for the property. So let's assume that the buyer does bid $20,000 at ME2's foreclosure sale. How are we going to distribute that money? Well, the answer is we'll give $15,000 of it to ME2. That's the full amount of the debt that's owed to ME2, so ME2 is fully paid off. We'll give the tenant the bonus value of the lease if there is any, and if there isn't, then we'll give the mortgagor the remaining $5,000. Now you'll notice we didn't give any of that money to ME1. Why is it that ME1 gets none of the proceeds of ME2's foreclosure? Well, the reason is, of course, the foreclosure by ME2 doesn't impair ME1's rights at all. ME1 still has the right to do their own foreclosure. They're completely unaffected by ME2's foreclosure, and so if there's a default to them and they don't get their money, they can always foreclose on the property later themselves. So we don't need to give them any of the money from ME2's foreclosure sale. We can summarize a great deal of what we've learned in this video by just 4 words. Foreclose down, redeem up. If you hold a mortgage on real estate, you can only foreclose on mortgages and other interests of lower priority than your own. Now that does include the interest of the mortgagor, who in effect is at the bottom of the priority list. On the other hand, you can only redeem from mortgages of higher priority than your own. So keep that little phrase in mind. Foreclose down, redeem up. That concludes video number 45, our introduction to the law of mortgages. In our next video, number 46, we'll provide an introduction to the law of zoning and land use planning. If you have questions or comments, email ProfDale01@gmail.com. Thanks for watching.